Today, we will discuss the concept of conditions and warranties under the Sale of Goods Act, 1930. These provisions are covered under sections 12 to 17 of the Act. It is usual for both seller and buyer to make representations to each other at the time of entering into a contract of sale. Some of these representations are mere opinions which do not form a part of contract of sale, whereas some of them may become a part of contract of sale. Representations which become a part of contract of sale are termed as stipulations, which may rank as condition and warranty. But mere commendation of his goods by the seller doesn't become a stipulation and gives no right of action to the buyer against the seller, as such representations are mere opinion on the part of the seller. But where the seller assumes to assert a fact of which the buyer is ignorant, it will amount to a stipulation forming an essential part of the contract of sale. Section 12 Subclause 1 deals with the condition and warranty and says, a stipulation in a contract of sale with reference to goods, which are the subject thereof, may be a condition or a warranty. The term condition is defined in Section 12 Subclause 2. Section 12 Subclause 2 says, a condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. Subclause 4 says that whether a stipulation in a contract of sale is a condition or a warranty depends in each case on the construction of the contract. A stipulation may be a condition, though called a warranty in the contract. That means, a condition is a stipulation which is essential to the main purpose of the contract, and the breach of which gives the aggrieved party a right to terminate the contract. If we discuss about the warranty, according to Section 12, Subclause 3, a warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not a right to reject the goods or to treat the contract as repudiated. In simple terms, a warranty is a stipulation, first, which is not essential to the main purpose of the contract, but is only subsidiary or collateral, and, second, the breach of which gives the aggrieved party the right to claim damages only, and not the right to terminate the contract or reject the goods. Thus, a warranty is of lesser importance compared to a condition. Section 13 discusses about the situation when conditions to be treated as warranty, and says that in the following three cases a breach of a condition is treated as a breach of a warranty. First, where the buyer waives a condition. Once the buyer waives a condition, he cannot insist on its fulfillment accepting defective goods or beyond the stipulated time amount to waiving a condition. Second, where the buyer elects to treat breach of the condition as a breach of warranty, where he claims damages instead of repudiating the contract. Third, where the contract is not severable and the buyer has accepted the goods or part thereof, the breach of any condition by the seller can only be treated as breach of warranty. It cannot be treated as a ground for rejecting the goods unless otherwise specified in the contract. Thus, where the buyer after purchasing the goods finds that some condition is not fulfilled, he cannot reject the goods. He retains the goods, entitling him to claim damages only. But nothing in this section shall affect the case of any condition or warranty fulfillment of which is excused by law by reason of impossibility or otherwise. Now the question is that, what is express and implied conditions and warranties? In a contract of sale of goods, conditions and warranties may be express or implied. The express condition or warranty means that condition or warranty which are fixed by agreement by seller and buyer. Here, we discuss only implied condition for which seller shall always responsible for goods sold. Now we discuss the implied condition. This may be explained under the following heads. First, implied undertaking as to title, etc. Section 14. Second, condition in case of sale by description, Section 15. Third, sale by description, Section 15. Fourth, implied conditions as to quality or fitness, as 16. Fifth, condition in case of sale by sample, Section 17. Let us now understand the first implied condition as to title under Section 14 of the Sale of Goods Act, 1930. In every contract of sale, unless a different intention appears, the law provides certain implied conditions and warranties. First, there's an implied condition that, in the case of a sale, the seller has the right to sell the goods, and in the case of an agreement to sell, he will have the right to sell at the time when ownership is to pass. Second, there is an implied warranty of quiet possession, which means the buyer shall enjoy the goods without any disturbance. Third, there is an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party, unless such charge is already disclosed or known to the buyer at the time of the contract. Thus, Section 14 ensures that the buyer gets valid title, peaceful possession, and freedom from hidden claims. Let us now understand the second implied condition in case of sale by description under Section 15, where there is a contract for the sale of goods by description. There is an implied condition that the goods supplied shall correspond exactly with that description. The basic idea is simple. The goods delivered must be the same as those described by the seller. A sale by description may arise in several situations. First, where the buyer has never seen the goods and relies entirely on the description given by the seller. Second, where the buyer has seen the goods, but still makes the purchase based on the description provided. Third, where the method of packing or other specifications are described, and the buyer relies on such description. Thus, in all such cases, it is the duty of the seller to ensure that the goods strictly match the description, failing which the buyer has the right to reject the goods. Let us now understand the third implied condition relating to sale by description under Section 15, where there is a contract for the sale of goods by description. There is an implied condition that the goods must correspond exactly with that description. This means the seller is bound to deliver goods that match what has been described, and any deviation gives the buyer a right to reject the goods. Further, where the sale is made by sample as well as by description, it is not enough that the goods correspond with the sample alone. They must also match the description given in the contract. Thus, both conditions must be satisfied. The goods must conform to the sample as well as the description. Fourth, implied conditions as to quality or fitness under Section 16 of the Sale of Goods Act, 1930. As a general rule, there is no implied condition regarding quality or fitness. However, the law provides certain important exceptions where such conditions are implied. First, when the buyer communicates his specific purpose to the seller. Second, when the buyer relies on the skill or judgment of the seller. Third, when the goods are of a description which the seller ordinarily deals in the course of his business. Fourth, where goods are bought by description from such a seller. There is an implied condition that the goods shall be of merchantable quality. Fifth, where the goods cannot be examined by the buyer. There is an implied condition as to latent defects that would have been discovered upon proper examination. Sixth, an implied condition or warranty may also arise based on the usage or custom of trade. And finally, an express condition or warranty does not exclude an implied one, unless it is clearly inconsistent with the provisions of the Act. Thus, Section 16 provides important safeguards to ensure that goods are fit, reliable, and of acceptable quality. Implied condition in case of sale by sample. First, we should know what is sale by sample. A contract of sale is a contract for sale by sample when there is a term in the contract, express or implied, to that effect. Now we will discuss what is implied conditions in sale by sample. Sale by sample is subject to the following three implied conditions. First, the bulk shall correspond with the sample in quality. Second, the buyer shall have a reasonable opportunity of comparing the bulk with the sample. Third, the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Let us now understand the concept of implied warranties under the Sale of Goods Act, 1930. First, warranty as to quiet possession under Section 14, Clause B. There is an implied warranty that the buyer shall have and enjoy quiet possession of the goods, meaning he should not be disturbed in his use or enjoyment of the goods. If this warranty is breached, the buyer has the right to claim damages from the seller. Second, warranty of freedom from encumbrances under Section 14, Clause C. There's an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party, provided the buyer is not aware of such charge at the time of the contract. If such an encumbrance exists and affects the buyer, he can claim damages from the seller. Thus, these implied warranties ensure that the buyer gets peaceful possession and clear title to the goods. Let us now understand the key differences between a condition and a warranty under the Sale of Goods Act, 1930. First, definition. A condition is a stipulation essential to the main purpose of the contract, whereas a warranty is collateral or subsidiary to the main contract. Second, breach impact. In case of breach of a condition, the aggrieved party can repudiate the contract and claim damages. But in case of breach of a warranty, the party can only claim damages. Third, nature. A condition is a fundamental term of the contract, while a warranty is a minor or subsidiary term. Fourth, remedy. Breach of a condition allows the buyer to cancel the contract and claim damages, whereas breach of a warranty allows damages only. Fifth, legal basis. Condition is defined under Section 12, subsection 2, and warranty under Section 12, subsection 3 of the Act. Thus, the distinction lies in the importance of the term and the remedies available upon breach.